the Human Rights Act 1998. S3 of the Human Rights Act specifies that, to the extent possible, laws must be interpreted and applied in a form that is consistent with the rights of the European Convention on Human Rights. It refers to any situation where one of the freedoms is involved, but it does not extend where there is no human rights presence. A great illustration of the disparity in understanding of the Human Rights Act is v. Offen, 2001. This case viewed the translation of the word exceptional in the Crime, Sentences, Act 1997, where a person committing a second serious offense must be sentenced to life imprisonment unless there are exceptional circumstances. Prior to the enforcement of the Human Rights Act, the judges in v. Kelly, 2000, had ruled that extraordinary was a common English term, saying, "To be exceptional, a case does not have to be unusual or unprecedented or very rare, but it cannot be one that is frequently, commonly, or ordinarily experienced." It contributed to a rigid policy where criminals were sentenced to life imprisonment, even when the early were sentenced to life. In Offen, the Court of Appeal ruled that this limited path may contribute to a penalty becoming unreasonable and unfair and a violation of Articles 3 and 5 of the European Convention on Human Rights. To define the Criminal Sentences Act in a way consistent with the Convention, it was important to consider whether the defendant was a threat to the public. Because he would not do so, he was the exception to the normal rule in the Act, and this could be treated as exceptional circumstances so that a life sentence would not have to be enforced. Conclusion. The mindset of the English courts to interpretation has changed over the years by moving forward toward the objective approach and boosting the use of extrinsic aid. Nevertheless, the procedure used to evaluate a law is still left to the particular judge, and it is quite likely that one judge will take a literal view, while another judge might draw the opposite conclusion by using the incorrect rule or the analytical approach. This problem is highlighted in the final case. In v. Registrar General, ex parte Smith, 1990, the court had to recognize S51 of the 1976 Adoption Act, which indicated 1. Pursuant to subsections 4 and 6, the Registrar General shall, on an application submitted in a specified manner by an adopted person, record the birth of which is held by the Registrar General and who has reached the age of 18 years, provide that person with such details as is necessary to enable that person to acquire a certified copy of the birth certificate. Subsection 6 claimed that, if the adoption took place before 1975, the Registrar General could not provide the details unless the claimant had taken part in an interview with the counselor. The case includes Charles Smith's request for information to allow him to receive his birth certificate. Mr. Smith presented his case in the proper way and was willing to see a counselor. In the literal sense of the Act, the Registrar General had to provide him with details, since the Act uses the phrase must provide. The issue was that Mr. Smith had been found guilty of 2 murders and had been arrested in Broadmoor as a result of reoccurring periods of psychotic illness. A doctor thought it was possible that he might be abusive to his real parents. This was a challenge for the court. Should the plain sense of the terms be enforced in this situation? The judges of the Court of Appeal decided that the case called for an objective approach, saying that, despite the simple language of the Act, Parliament couldn't have designed to promote serious crime. Consequently, in spite of the danger to the natural mother of the claimant, if she revealed her identity, they held that the Registrar General did not have to provide any details. It is interesting to note that the law is itself a rule-based construction and that these rules are partly based on social and ethical rules. It is reasonable for the statutory interpretation to be labeled rules. Laws are used in many things, from football games to the mark used in a given working environment. We are responsible for regulating and directing conduct or acts against which activity or behavior can be measured and evaluated. Rules have set a standard. In general, it is possible to apply to cases without having to reassess the inherent value of each case. This provides for a consistent outcome that can be both predicted and stable. There is, nevertheless, the possibility that, as the legislation is articulated in words, there are variables that will affect the understanding and execution of the legal rules, but that, despite having a set of guidelines to obey in the interpretation of the rules, the outcome does not imply rigidity, and it is probable for the consequence to be a false result. But, the rules of the statutory interpretation are diverse. It is not a single set rule, and thus the most effective rule should also have adhered in the context of the case. Currently, the regulations allow for reflection and are the reference point for the most appropriate action to be taken to uphold the law. Answer structure: P1 you will be marked based on your commentary and comparison in the law, backed by case laws. What you need to do is 1. Introduction: mention all that you will discuss in the essay, add case laws and laws in brackets for each rule, describe the question. 2. Describe the law. 3. Explain the law. 4. Give case laws. 5. Compare and comment on which one is better, and why is it better. 6. Give the advantages and disadvantages of both. 7. Explain which one you will choose. Keep in mind how to interpret the law using these rules of interpretation, rules of language, and the extrinsic and intrinsic aid, and you are good to go for that A. Get complete notes in PDF and book form from our Amazon store. Link given in description.